5 seconds to go. Start. After committal and upon denial of charge by the appellant, the case was tried as Sessions Case number 9 of 2008 by the Sessions Judge Mahila Court, Preambalpur. In trial, a total of 14 witnesses were examined by the prosecution. The first witness, PW1 Bashira, mother-in-law of the appellant and the informant, was examined as the key witness related with the occurrence. Four other witnesses, PW2 Mumtaz, daughter of PW1, PW3 Asha Begum, other daughter-in-law of PW1, PW4 landlord of PW1, and PW5 neighbor of PW1, were claimed to be the witnesses who reached the scene of crime immediately after the occurrence. PW8 and PW13 testified respectively to the post-mortem report and the report with respect to the thyroid cartilage bone of the victim child. PW9 Devraj, village administrative officer, and PW7 were examined as attesting witnesses related with the process of investigation. PW10 had recorded the statement of PW1 and scribed the FIR, whereas PW11 was the photographer who had taken photographs at the scene of occurrence. As noticed, PW12 carried out the initial investigation, whereas PW14 completed the investigation and filed charge sheet. Apart from these witnesses who supported the prosecution case, there had been another witness, PW6, father of the appellant, who stated to the contrary and asserted that the appellant was with him at his village Kolakudi. In other words, this witness supported the appellant's plea of alibi. Though elaboration of the entire prosecution evidence is not necessary for the purpose of the present appeal, but having regard to the contentions urged, we may take note of the relevant part of depositions, particularly in reference to certain inconsistencies, discrepancies in the assertions of the prosecution witnesses, as also in reference to the appellant's plea of alibi. PW1 Bashira has been the key witness for the prosecution. In her testimony, she stated that her son had married the appellant, that a female child was born to the appellant after the marriage, and that Abdul Rahim was sending all the money earned by him to the appellant. She further stated that Abdul Rahim had called her to say that his daughter should be admitted in a school in Periambalpur and he would send her money for that purpose, and subsequently on 18th June 2007, PW6, father of the appellant, dropped the appellant and the child to the house of PW1 with the request to educate the child in Periambalpur, since Abdul Rahim was allegedly not sending the appellant any money. She stated that on the morning of 21st June 2007, the appellant gave her rupees 100 and asked her to buy idli, that when she came back to the house, the appellant was sitting silently next to the child, and that upon asking, the appellant told her that she had killed the child. During cross-examination, this witness stated that she went to the police station with the appellant immediately after the occurrence. The relevant parts of her statement read as under. About 10 months ago, 18th day of 6th month, My daughter-in-law's father had brought his daughter, the margin accused, and our grandchild to my house at Priyambalpur. My daughter-in-law's father was telling his daughter, the margin accused, that on the next day, 19th, he would be leaving to his village and she has to take care of everything. The margin accused told her father that she would take care. On the next day, 19th, the accused's father went back to his village. On the next day to that, on 20th, Wednesday, we cooked and had our food and were available in the house of my daughter Mumtaz. I am residing separately after 4 or 5 houses from her house. The witness repeats the same. I told the margin accused to come to my house along with her daughter and we would admit the granddaughter in school. Stop.